Hi, John Bryan here, West Virginia civil rights lawyer, thecivilrightslawyer.com. Here just today, we finally filed the Outlaw Barber case, which is the case of Les Jenkins, a 73-year-old retired Deputy U.S. Marshal, combat veteran off of a swift boat in Vietnam, 5-decade-long barber who now lives on a small farm with his wife of 50 plus years and takes care of rescue animals and has his only source of income being his little barbershop that he has in Berkeley County, West Virginia, a little town called Inwood, West Virginia. And this man was physically arrested back during the lockdown period in April of last year because of the executive order of our tyrannical trash governor, arrested by two sheriff's deputies who clearly didn't know what they were doing at the direction of one of these health Nazis, this woman who is an inspector with the completely useless West Virginia Board of Barbers and Cosmetologists. So this is one of the actual few people who, according to the governor's threat, was actually arrested, physically arrested and transported for incarceration by law enforcement who were purporting to carry out these tyrannical and unconstitutional orders by our governor. Now, he wasn't arrested for violating the executive order because that's not actually a statute that they could cite. He was arrested for the general obstruction statute. Now, the inspector from the Barbers Board who started this whole thing, her husband is a prosecutor in the same county. And she mentions that in the body cam footage if you've seen it. And if not, you can still watch it. Now, it may be a coincidence, but instead of dismissing these ridiculous, frivolous charges, they instead aggressively prosecuted Mr. Jenkins, tried to convict him. In fact, it happened on April 23rd that he was arrested and charged, and he wasn't able to get out from underneath his prosecution until January of 2021, which is extremely unusual for a misdemeanor obstruction charge in West Virginia. They tried to prosecute him and get a conviction, and ultimately they failed because the courageous magistrate court judge dismissed the criminal prosecution because it violated the constitutional rights of my client. So we finally, just here today, filed a Section 1983 civil rights lawsuit, and it's up at the website on thecivilrightslawyer.com. You can review it in full, and also at the link, which I'll put in the description, you can also watch the body cam footage from this incident that I put in the, that I had already done a video on that caught a lot of what went on there that day. But there are three claims that we made. So this is a Section 1983 lawsuit where you allege that there have been deprivations of federal rights, federal laws, by somebody acting under color of law, either a government employee, police officer, health inspector, inspector for the Barbers Board, whatever. And the rights that were deprivated, if that's a word, Fourth Amendment and First Amendment. Now, primarily, this was a Fourth Amendment case, so I've separated the Fourth Amendment claims into two separate counts. So one, and you'll have to watch the video for this, but when the officers arrive, they just go in his barbershop and kind of confront him. I'll tell you specifically what was said. I went through all the videos, and it's great that we had the videos available. This was March or April 23rd of 2020. So the two deputies, one, was a male and a female. The male was Deputy Robinson. Female was Deputy Weidman. Again, Berkeley County Sheriff's Office, Eastern Panhandle of West Virginia. They were in uniform, and fortunately, Weidman was wearing a body camera, and that's where we got the footage from. But let me back that up. Actually, before they go in, they meet the inspector outside from the Barbers Board, and this is what she says. I knocked on his door, referring to my client, because I'm immune comparable. So I'm trying not to be out here. My husband just had surgery, and I'm trying not to bring anything back to him, So I knocked on his door, I asked him to come outside. I told him, that there's a mandate. You have to be closed. All the other shops are closed. So I'm doing my job, asking you to close down. We don't want you to get the other people sick or anything to happen, He's like, well, I wasn't aware of this. Sure. So after this, the deputies just walk in, and the male, Robinson, they didn't ask for permission to enter or anything like that. The door wasn't locked. Robinson walks up to my client. There's no customers in the store. And he says, you have to be shut down, right? My client responds, referring to the inspector, she arrived here at 9 o'clock a.m., said she'd received a complaint that he was open for business. She said that she had to shut me down, and I said I needed her order in writing and to sign it. Because what happened is my client initially complied, and he shut down until he started to run out of money. That was his sole source of income. So he goes to a bank to try to get a PPP loan because he has a cash-only business as a barber. They wouldn't give him a PPP loan. He goes to Workforce West Virginia, which is the unemployment office, and they told him that he didn't qualify for unemployment unless he can get some sort of verification in writing that he's been ordered to close down. So that's why he's asking this woman to, all right, put it in writing and sign it. Verify for me in writing so I can get unemployment if you're going to shut me down. So that's what he asked for. That's what he told the deputies when they arrived that he had asked for. So Weidman, who has the body camera, then goes back outside to speak with Inspector Kinzer and asks her if she has a copy of the order that she can provide to Mr. Jenkins. And she says, no, my office is in Charleston and I'm rarely there, so I can't provide him with a hard copy. So she looks it up on her phone, hands the deputy her phone. The deputy then goes back inside the barbershop and hands the phone to the other deputy, who hands it to my client. My client says, nope, I need it in writing. I need it in writing, and I want her to sign it. So eventually, the Kinzer came back with a hard copy of the governor's executive order and said that she wasn't going to sign it because some unnamed individual told her not to sign it. And so my client said, well, that's still not sufficient. And, if you're going to arrest me, you're going to arrest me. And so they ended up arresting him. And he asked if he could lock the doors to his business, before he got arrested. They allowed him to. So they physically arrested him and transported him to the sheriff's office for processing. They ended up incarcerating him for about 3 hours before he posted bond, which was a $500 PR bond. And again, they prosecuted him thereafter for months and months and months and months and months and months. Finally, when his lawyer filed a motion to dismiss and it came up for hearing, the judge dismissed it. And that wasn't until January. Now, at the same time that they were doing this, the Barbers Board itself was taking administrative action also, in addition to the pending criminal case, trying to take Mr. Jenkins' license. And fortunately, at some point, the Attorney General of West Virginia stepped in and issued a press release and said this: exercising one's right to inquire about the legal nature of an executive order should never result in the revocation of one's license to do business, and I commend the board for its ruling. And what he's talking about is, if you watch the body cam footage, Mr. Jenkins is questioning their authority to close his business and to to close his business. He's questioning their authority. And he's saying that he's, has legal counsel, that he's going to challenge it. He may file a lawsuit, but he's questioning their authority. And that's where the First Amendment, you'll see, is going to come in. And the Attorney General was right about this. So finally, they dismissed the administrative complaint at the behest of the Attorney General. He received a letter in the mail stating that the administrative complaint was dropped, but they were still trying to get him on the criminal charge. So here's what the counts are. 2 counts for violating the Fourth Amendment. 1 is the actual entry itself and the initial seizure, the investigative detention that took place. And the second Fourth Amendment event is the actual arrest. So that's basically false arrest. But they're both violations of the Fourth Amendment. Now, when they first walk in, they're wearing uniforms. They don't ask for permission to come in. They don't have a warrant. So I'm alleging here that this was basically an overt show of authority of, hey, we're law enforcement officers. And at that point, they didn't ask for anything. They just said, hey, I confronted them. You're supposed to be shut down, right? And that was an overt show of authority as uniformed law enforcement officers. And I would contend that the seizure had begun, and it was an investigative detention at that point. And ultimately, they arrested him. So that's the first count. That's the first, Fourth Amendment event. And the second count, also a Fourth Amendment violation, is the false arrest itself. So what did we have there? They arrested him for violation of state obstructing an officer. State statute of obstructing an officer. That's West Virginia Code 61-5-17. And that says any person who threats, by threats, menaces, acts, or otherwise forcibly or illegally hinders or obstructs or attempts to hinder or obstruct any law enforcement officer, blah, 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 is guilty of a misdemeanor, blah, 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 blah. So that's a state misdemeanor violation, and they did not have an arrest warrant, so therefore that was a warrantless arrest. What do you need to perform a justified warrantless arrest in West Virginia or anywhere else? Well, you need probable cause. And if there's no probable cause, then that is a Fourth Amendment violation. That's a false arrest, unreasonable search and seizure, whatever you want to call it. Now, another thing in West Virginia is, because remember, states can offer more protections to their citizens. They just can't offer less than the federal baseline of protections under the Fourth Amendment or any other amendment. So West Virginia actually requires that if a police officer is going to make a misdemeanor arrest, that arrest has to occur, or that violation, that offense, has to be witnessed by the officer, has to happen in the officer's presence. Otherwise, they have to go get an arrest warrant. And so if they're saying that by cutting hair the day before, including he cut some police officers' hair, that was the criminal activity that he engaged in. Well, that didn't happen in the presence of those officers. When they came in, there were no customers in there at all. And in fact, the executive order doesn't say he has to close. It just says that he's not allowed to bring in the general public. So arguably, he can be in there. He could ship out hair care products via mail or through a slot in the door. Or he could even cut the hair of so-called emergency or essential workers. So, I mean, perhaps that's why they didn't charge him with violation of the executive order, which of course isn't a thing. They charge him with obstruction. So how did he forcibly hinder or obstruct the officer from his investigation? Well, the only thing he didn't do is the officer telling him to close, and he didn't close, or theoretically. So if that's the violation, then let's look at the case law on obstruction. And really, the funny thing is, there was just in 2019 a Fourth Circuit case that came out of West Virginia on obstruction, and it really is on point to this. And the case is called Hupp versus State Trooper Seth Cook, Fourth Circuit 2019, and it was actually defended by a defense lawyer who's a friend of mine. I don't remember him saying anything about this case. It's been a while since we've had a case together, but this is crazy, like on point to this situation. Here's what the Fourth Circuit had to say about West Virginia obstruction law. As West Virginia's High Court is, and I put all this in the lawsuit if you want to check it out. As West Virginia's High Court has succinctly explained, to secure a conviction under Section 61-517A, that's obstruction, the state must show forcible or illegal conduct that interferes with a police officer's discharge of official duties. Because conduct can, and blah, 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 but basically here's what it says. When force is not used, obstruction lies only where an illegal act is performed. This is because lawful conduct is not sufficient to establish the statutory offense. And of particular relevance to our inquiry here, West Virginia courts have held that when done in an orderly manner, merely questioning or remonstrating with an officer while he or she is performing his or her duty does not ordinarily constitute the offense of obstructing an officer. and they cite State versus Snirsky, 2003. For example, the Supreme Court of Appeals has found that no obstruction is committed when a property owner asks a law enforcement officer, without the use of fighting or insulting words or other opprobrious language, and without forcible or other illegal hindrance, to leave her property. This principle is based on the First Amendment right to question or challenge the authority of a police officer, provided that fighting words or other opprobrious language is not used. So peaceful verbal criticism of an officer who's making an arrest cannot be targeted under a general obstruction of justice statute. And as the West Virginia Attorney General pointed out, my client should not be retaliated against for exercising his First Amendment right to inquire about the legal nature of an executive order and what his rights are, and questioning those rights. His license shouldn't be attacked, and he really shouldn't be physically arrested and incarcerated. So that's what Mr. Jenkins was doing. If you watch the videos, he was questioning the authority of the governor. He was asserting his constitutional rights. And in response to that, he was physically arrested and incarcerated for 3 hours. His business shut down. So I've also included here a First Amendment claim. So these are all Section 1983 claims, different counts, and one lawsuit. So it was just filed today. And I suspect this one you'll see it in the news. There was already a Federalist article, a great article on it, and the failings of the West Virginia bureaucratic state. It really is educational on different levels. So check all this stuff out, and we'll be serving the defendants, and there may be even more defendants. We'll see what the current defendants have to testify to, and make sure you follow. Subscribe to civilrightslawyer.com, and there definitely will be some updates on this case. This will be a fun one, so follow along, and I will definitely keep you updated on this one.